Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner. In today's video, we are going to discuss Bharatiya Nyaya Sanhita 2023 from section 45 to section 62, Abetment and Conspiracy.
Today, we're diving into a really critical concept from our new criminal laws, abetment, which is now defined under Section 45 of the Bharatiya Nyaya Sanhita, 2023. So, here's how we're going to tackle this important topic. First, we'll get a solid introduction to Section 45. Then, we'll break down its core ingredients, look at a practical example, and discuss a landmark case. After that, we'll see how the new law connects to the old one, why it's so important for your exams, and then we'll finish up with a quick revision.
All right, let's kick things off with our first section, a proper introduction to Section 45. This is all about understanding the very foundation of abetment in our new legal system.
आज हम डिस्कस करेंगे सेक्शन 45 of the Bharatiya Nyaya Sanhita 2023. This section is absolutely fundamental if you want to understand what we call inchoate offenses. That is, crimes that have been set in motion, but maybe haven't been fully completed.
So this quote right here gets to the heart of it. But what does it mean in simple terms? Well, abetment is basically encouraging someone, planning with them, or helping them to commit an offense. The most crucial thing to remember is that abetment is a separate crime all by itself. You don't have to be the one who does the final act. Just doing one of these three things can make you liable.
Moving on to our second section. Let's really break down this definition into its three core parts. Getting a handle on these is absolutely key to mastering abetment for your exams.
इस सेक्शन में तीन इंपॉर्टेंट चीजें हैं. First, instigation. Second, conspiracy. And third, aiding. You can think of the entire concept of abetment as standing on these three pillars.
First up, we have instigation. This is all about pushing, encouraging, or provoking someone to commit a crime. So, for example, if someone says, hey, go and hit that person, that is a crystal clear case of instigation. And it's not just direct words. Deliberately giving someone false information to make them commit an offense also counts.
Second is conspiracy. This happens when two or more people agree to commit a crime together. But, and this is a really crucial point to remember, just having a plan isn't enough. For it to count as abetment by conspiracy, some action must be taken based on that agreement. The plan has to be put into motion.
And our third ingredient is aiding. This is pretty straightforward. It just means giving active help. For instance, if you give someone tools so they can commit a burglary, or if you drive the getaway car after a robbery, well, those are classic examples of aiding an offense.
Now, to really make sure we've got this down, let's look at a practical example. Pay close attention, because this is the kind of scenario you're very likely to see in your exam questions. Okay, so imagine this. A tells B, go burn X's car, and B actually goes and does it. In this situation, A is guilty of abetment by instigation. It's a textbook example, really, and it shows a direct line from the act of instigation to the crime itself.
Let's now turn to a landmark judicial interpretation. Understanding the important case laws is absolutely vital for scoring well, especially in your mains exams. It shows you understand how the law works in the real world.
In the famous case of K.M. Nanavati versus the state of Maharashtra, the Supreme Court made a very important point. It held that instigation and planning are enough to count as abetment, even if the person who did the planning didn't directly participate in the final act. This case is so significant because it widened the scope of who can be held responsible for a crime.
In our next section, let's focus on the new law and, more importantly, its relevance for your upcoming exams. We'll connect it to the old law so you have complete clarity.
So, this new provision, Section 45 of the Bharatiya Nyaya Sanhita 2023, well, ये section पहले IPC का Section 107 था. So while the section number is changed, and of course the name of the act is new, the core legal principle of abetment has pretty much stayed the same.
So what's the bottom line for you as an aspirant? Listen closely. Judiciary prelims or mains dono ke liye ye section बहुत important hai. And you can definitely expect direct questions on this in the APO exam. It's often tested with other major crimes like fraud, murder, and theft to see if you can apply the law to complex situations. All right, to wrap things up, let's do a super quick revision of the key points from our discussion. This will really help lock everything in for your exams.
So, to recap, we've been talking about Section 45 of the Bharatiya Nyaya Sanhita, 2023. Its core concept is abetment, which can be done in 3 ways, through instigation, conspiracy, or aiding. And please remember, this is a very high-yield topic for both your judiciary and APO exams.
For more judiciary-focused legal content just like this, make sure you stay connected with us here at Ganga Education.
Today, we're going to dive into a really crucial topic from the new criminal laws, something that's absolutely essential for your upcoming exam preparation. So let me start with a question for you. Can you actually be found guilty for a crime that you didn't commit yourself? It's a fascinating thought, right? And this very question takes us straight into a critical area of criminal law. All right, to answer that question, आज हम discuss करेंगे Section 46 of the Bharatiya Nyaya Sanhita 2023. You see, this is the section that deals with the concept of an abettor. So, what exactly does this section say? Let's start by looking at the definition itself and break it down into simple, easy-to-understand terms. Okay, so the Bare Act says, and I quote, "A person abets an offense who abets either the commission of an offense or the commission of an act which would be an offense." Now, what does that really mean in simple terms? Well, think of it this way. Abetment is basically encouraging someone to commit a crime, or planning it with them, or even just helping them to carry it out. Now, to really get a grip on this concept, it's super helpful to break it down into what we can call the 3 pillars of abetment. It makes it so much easier to remember. So the law lays out 3 different ways a person can be an abettor. First, we have instigation, or uksana. This is when you're actively encouraging or, pushing someone to commit the crime. Second, there's conspiracy, or shadyantra, which is pretty straightforward. It's about planning the offense with others. And third, we have aiding, or sahayita, which means you intentionally help them out. And remember, doing just one of these things is enough to be considered abetment. Legal stuff like this always makes more sense with a real-life example, doesn't it? So let's look at a quick scenario that will really help you lock this concept in for your exams. Okay, so picture this. Let's say person A instigates person B to murder person C, but B says no way and just refuses to do it. Now, here's the key takeaway, and this is really important. Even though the murder never actually happened, A is still guilty of abetment. Why? Because the act of instigation is in itself a complete offense. What the law is really looking at is the abettor's intention and their action, not necessarily whether the final crime was committed. And as all of you preparing for mains know, citing landmark cases is absolutely vital for scoring those extra marks. So, let's take a look at a key Supreme Court case that illustrates this exact point perfectly. All right, the case is R versus Jogendra Singh from 1955. In this case, the Supreme Court held that the act of instigating someone to commit an offense is punishable on its own. It doesn't matter if the main offense was actually carried out or not. You see how this principle directly backs up the example we just talked about? Okay, let's shift gears a bit. We need to talk about how this fits in with the old law and really hammer home why this section is so important from an exam point of view. So it's super important for you to know that this provision used to be Section 108 of the Indian Penal Code 1860. That's the old law. It has now been replaced by Section 46 of the Bharatiya Nyaya Sanhita 2023. Remembering this change is non-negotiable for your exams, really. And let me just be crystal clear about this. Judiciary prelims और mains दोनों के लिए ये section बहुत important है. You can definitely expect direct, concept-based questions on this topic in the APO exam as well. So having a solid understanding is, well, it's a must. Okay, before we finish, let's quickly wrap things up. To make sure all this information sticks, we're going to do a quick, final 3-point revision of the key takeaways. So here's what you absolutely have to remember. Point 1. The concept of an abettor is now covered under Section 46 of the BNS 2023. Point 2. The whole idea of abetment boils down to 3 core actions: instigation, conspiracy, or aiding. And point 3. This is a really high-yield topic for both your judiciary and APO exams. Don't forget it. For more judiciary-focused legal content like this, make sure you stay connected with us here at Ganga Education.
Today, we're diving into a really crucial topic from the new Bharatiya Nyaya Sanhita 2023. We'll be breaking down extraterritorial abetment, which is covered under Sections 47 and 48. So let's get started. So, Imagine this for a second. A crime is planned in Delhi, but the actual act happens all the way over in London. The big question is, can the person who did the planning in India be held liable here? It's a classic legal puzzle, and thankfully, the Bharatiya Nyaya Sanhita gives us a very clear answer. Here's what we're going to cover in this session. We'll start with the idea of jurisdiction beyond borders. Then, we'll take a deep look at Section 47, which covers instigation from India. After that, Section 48, which is instigation into India. We'll compare them side by side, and then wrap up with a focus on why this is so important for your exams, followed by a quick revision.
You know, a core principle in criminal law is jurisdiction. But what happens when the planning and the crime itself happen in different countries? Well, the Bharatiya Nyaya Sanhita has specific provisions to make sure that criminals can't just use geography as an escape route to avoid liability.
Okay, let's break down the first scenario, which is handled by Section 47. This section comes into play when the person who is abetting the crime, the instigator, is physically present in India, but the crime itself is committed outside of India.
So, let's get right to it. आज हम डिस्कस करेंगे Section 47 of the Bharatiya Nyaya Sanhita 2023. Let's look at what the law actually says.
This line is the heart of the section. So, what does it mean? ये कहता है कि अगर कोई पर्सन इंडिया में रहते हुए इंडिया के बाहर किसी ऐसे एक्ट के लिए उकसाता है जो अगर इंडिया में किया जाता तो एक ऑफेंस माना जाता, तो उस पर्सन को अबेटमेंट के लिए लायबल माना जाएगा. Simple as that. So, to break it down, इस section में 3 important ingredients हैं. First, the abettor has to be in India. Second, the offense itself must happen outside India. And third, and this is key, that act, if it were done in India, would have to be a punishable offense.
Let's make this crystal clear with a practical example. Suppose person A is living in Mumbai. From there, he instigates B, who is in the USA, to poison C in New York. Now, even though the actual poisoning happens in the USA, A will be held liable for abetment right here in India, all thanks to Section 47.
And here's a crucial point for your exams. ये नया Section 47 of the BNS 2023 has replaced what was earlier Section 108A of the Indian Penal Code. So remember that the old section is now gone.
All right, now let's flip the scenario completely. What happens when the person doing the abetting is outside India, but the crime is committed right here inside India? Well, that situation is covered by Section 48. So now, we will be analyzing Section 48 of the Bharatiya Nyaya Sanhita 2023. This one deals with abetment that originates from outside the country. As you can see, this section states that if a person from outside India abets an offense that takes place in India, they will be held liable under Indian law. It really shows the long arm of our legal system, doesn't it?
And just like the last section, this one also has 3 core components, which are basically the reverse of Section 47. First, the abettor is outside India. Second, the offense is committed in India. And third, of course, the act is a recognized offense in India.
For example, let's say A lives in London and instructs B in Delhi to murder C, who is also in Delhi. Now, even if A has never even set foot in India, they will be held liable for abetment here. A very important landmark case on this point is Mubarak Ali Ahmed versus the state of Bombay. In this case, the Supreme Court held that even if the accused isn't physically present in India, if the crime here is a direct result of their actions abroad, Indian courts absolutely have jurisdiction. So now that we've understood both sections on their own, let's put them side by side. This comparison will help build a really clear mental framework, especially for your exams. Just look at this table. The difference is perfectly clear, right? In Section 47, the abettor is in India and the offense is outside. Whereas in Section 48, the abettor is outside India and the offense is inside. You see? They are perfect mirror images of each other. Remembering this simple concept is absolutely key for your exams. And now we've reached the most important part of our session, the exam focus and a final quick revision. This part is especially crucial for all you Judiciary and APO aspirants out there. So please pay close attention. For both Judiciary prelims and mains, these sections are very, very important, and you can expect a direct situation-based question on this topic in the APO exam, so make sure you've got this concept down cold.
All right, let's do one final revision. Section 47. Abettor is in India, offense is outside. Section 48. Abettor is outside, offense is in India.
The core concept behind both is to extend Indian criminal liability beyond our country's borders. Remember that, and you'll be good to go. For more judiciary-focused legal content just like this, make sure to stay connected with Ganga Education.
Today, we're going to dive into a really important part of the new Bharatiya Nyaya Sanhita 2023. Look, if you're preparing for judiciary or APO exams, understanding these new laws is absolutely essential. So let's just jump right in.
So, what are we looking at today? Well, we're going to break down a key section in the BNS. This one's all about the punishment for abetment. You know, a concept that's just fundamental if you want to understand criminal liability.
आज हम डिस्कस करेंगे सेक्शन 49 of the Bharatiya Nyaya Sanhita 2023. Make sure you pay close attention because this is a section you'll absolutely need to know for your exams.
Okay, so first things first. Let's look at the core legal provision, right from the BEAR Act itself. This section, you see, it sets out the general rule for what happens when someone abets a crime and that crime actually gets committed. Now have a look at the language here. It's pretty straightforward, right? What it's basically saying is this: if you encourage or help someone commit a crime and they actually go ahead and do it because of your help, well, you're going to get the exact same punishment as the person who actually committed the act. It's that simple. In the eyes of the law, the abettor and the main offender, they're on the same level. So to really understand this section, you need to know its key ingredients. There are 4 things that have to be there for this section to apply. First, there must be an act of abetment for an offense. Simple enough. Second, and this is important, the offense has to actually be committed. Third, the crime must be a direct result of that abetment, because of the instigation or the conspiracy or the aid provided. And finally, this section only applies when there's no other specific punishment mentioned anywhere else in the Sanhita for that particular abetment.
All right, all this legal text can feel a bit abstract, right? The best way to understand these concepts is with a practical example. So let's look at a simple scenario to see how this all works in the real world. Okay, check this out. It's a perfect illustration. Let's say person A tells person B, hey, go burn down C's shop. That's the instigation. Now, what happens next? B actually listens and sets the shop on fire. That's the commission of the crime. So what's the consequence? Under Section 49, A is now guilty of abetment and is liable for the very same punishment that B gets for the crime of arson. It's a great way to remember it. The mind behind the crime is considered just as guilty as the hand that actually does it.
Now, it's one thing to read the law, but how do the courts actually apply it? This is where case law becomes so important, especially for your exams. Let's look at a landmark ruling to see how this section is interpreted in practice.
A really important case here is Jamuna Singh versus the state of Bihar from 1967. In this case, the Supreme Court laid down a supercritical principle. The court held that an abettor can be punished even if the main offender is acquitted or isn't caught or isn't convicted for some reason. What's the only thing that needs to be proven? That the crime was committed because of the abetment. This is huge. It means the abettor's liability is totally independent of what happens to the main offender.
Okay, so let's get to the part you've been waiting for. Why does this matter for your exams? How will this help you score? Let's focus on the absolute must-know points. First up, a crucial point for your prelims. You might be wondering, what about the old law? Well, Section 49 of the Bharatiya Nyaya Sanhita 2023 is the new version of what was Section 109 of the Indian Penal Code 1860. This comparison is something you absolutely have to remember. And just to be super clear, this section is incredibly important. We're talking both for prelims and for mains in your judiciary exams. And for the APO exam, you can definitely expect direct questions on this. They might ask something like, what is the punishment for abetment under the BNS? Or, which section of the IPC corresponds to Section 49 of the BNS? So be prepared. Okay, before we wrap up, let's do a really quick revision. Just 3 key points to lock this topic in your mind for good. So, to sum it all up, number 1, we've been talking about Section 49 of the Bharatiya Nyaya Sanhita 2023. Number 2, the core concept to remember is simple. The abettor gets the same punishment as the main offender as long as the act was actually committed. And number 3, its exam importance is huge. It's essential for both prelims and mains in judiciary and APO exams. For more judiciary-focused legal content just like this, make sure you stay connected with us here at Ganga Education. Today, we're going to tackle 2 foundational sections of the Bharatiya Nyaya Sanhita 2023 that deal with abetment liability, Section 51 and Section 52. You know, these sections are incredibly important for your exams, So let's dive right in. I want you to imagine a situation for a moment. What if you encourage someone just to commit a robbery, but during that robbery, a murder is also committed? Now the question is, are you also guilty of that murder? It's this exact kind of complex legal puzzle that sections 51 and 52 of the BNS are designed to solve.
So we're going to start with Section 51. This section is all about what we call the principle of probable consequence. Essentially, it helps define the limits of an abettor's liability when the result of their instigation turns out to be something completely different than what they intended. Okay, let's get into the details. On your screen now is Section 51 of the Bharatiya Nyaya Sanhita 2023. Let's break down its core principle. The law here is actually very clear. In simple terms, if you abet one crime but a different act or crime ends up happening, you can still be held liable for that second act. Your liability is treated as if you had directly encouraged that second crime from the very beginning. Now, this section has three important ingredients you have to remember. First, different act is done, which means the crime that was committed is different from the one that was encouraged. Second, and this is the key, probable consequence. That different act had to be a likely or probable outcome of the original abetment. And third, under the influence, the act was committed because of that original instigation, aid, or conspiracy. Let's make this crystal clear with a practical court example. Imagine a scenario where A tells B to attack C with sticks.
Now, during that attack, C suffers such severe injuries that he dies. The big question is, will A be held liable for murder? The answer is yes, but with one very important condition. A is liable if death can be considered a probable consequence of such a brutal attack with sticks. You know, this principle has really deep historical roots, as we can see in the landmark case of R.V. Saunders and Archer. In this case, the court held that liability exists when the final act, like death, is a probable consequence of the initial act, even if the actual victim wasn't the one who was originally targeted.
From an exam point of view, it's really important to remember that this section used to be Section 111 of the Indian Penal Code 1860. Now, in the Bharatiya Nyaya Sanhita 2023, it's Section 51. But the core legal principle remains exactly the same.
Okay, so that raises another question. What happens if, along with the act that was abetted, a completely new and separate crime is also committed? Well, this situation leads us straight to our next section. And that's where Section 52 of the BNS comes in. This section takes the principle of Section 51 a step further and provides for cumulative punishment for any additional acts that are committed. So let's now formally examine this provision. On your screen is Section 52 of the Bharatiya Nyaya Sanhita 2023. Let's see what it says.
The key phrase here is liable to punishment for each of the offenses. This clearly means that the abettor will not only be punished for the act they abetted, but they'll also face a separate punishment for any additional and distinct offense that was committed.
Section 52 also has three essential components. First, act done in addition, meaning an extra act was performed. Second, constitutes a distinct offense. This additional act must be a separate crime in its own right. And third, this is the most important one, abettor knew it was likely. The abettor had knowledge that there was a strong possibility of this additional offense being committed.
Let's clear this up with another example. For instance, A encourages B to break into a house simply to commit trespass.
But during the break-in, B assaults the owner and causes grievous hurt. So, is A liable for both the trespass and the grievous hurt? The answer is yes, but only if A knew that violence was a likely outcome of the break-in. You see, here, the abettor's knowledge is the most critical element.
This principle was reaffirmed by the Supreme Court in the case of Chitresh Kumar Chopra versus the state. The court held that abetment also includes intentionally creating circumstances where you know that multiple offenses are likely to be committed.
And, from an exam perspective, please also note that Section 52 of the BNS used to be Section 112 of the Old Indian Penal Code.
All right, it's time for a quick revision. For your upcoming exams, please make sure you focus on these key points. Understanding the core difference between these two sections is absolutely crucial. Section 51 applies when a different act is committed, as long as it's a probable consequence. Meanwhile, Section 52 applies when an additional and distinct act is committed for which cumulative punishment can be given.
Always remember, for both judiciary prelims and mains, these sections are extremely important. In APO exams, you can definitely expect direct problem-based questions on this topic. Examiners tend to focus specifically on the principles of probable consequence and the abettor's knowledge. So, to quickly summarize our discussion, Section 51 establishes liability for a different act based on probable consequence. Section 52 provides for cumulative punishment for an additional act based on the abettor's knowledge, and the core concept of both is that the mastermind, the abettor, cannot easily escape the grip of the law. For more judiciary-focused legal content, stay connected with Ganga Education.
Today, we're jumping into a really critical topic from the Bharatiya Nyaya Sanhita, 2023. We're talking about expanded liability and abetment. Now, we're going to focus specifically on 3 key sections, 53, 54, and 55, and I'll break down exactly what they mean and why they are so important for your upcoming exams. So let's get right into it. So here's our game plan for today. First, we'll quickly introduce what this whole idea of expanded liability really is. Then, we'll go section by section, starting with 53, then 54, and finishing with 55. And to wrap it all up, we'll do a quick-fire summary and I'll share some key exam tips you won't want to miss. So what does expanded liability even mean? Well, think of it like this. An abettor, that's the person who encourages or helps someone commit a crime, can be held responsible for more than just what they intended. They can be held liable for the probable consequences of their actions, even if those consequences are way more serious. It's really about holding people accountable for the entire chain of events they start. Okay, with that in mind, let's get into the specifics. Okay, let's kick things off with our first deep dive. आज हम डिस्कस करेंगे Section 53 of the Bharatiya Nyaya Sanhita 2023. This one deals with a really interesting legal puzzle. What happens when the actual result of a crime is totally different from what the abettor had in mind? Now, look at the wording here. It's incredibly powerful. What it's basically saying is that if you abet an act and a much more serious thing happens, you're still liable for that serious outcome. But here's the catch. The most important part of this whole section, you are only liable if you knew that more serious outcome was likely to happen. That element of knowledge is the absolute key. So to make this super clear, there are 4 essential ingredients for this section to apply. First, there has to be abetment of some act. Pretty straightforward. Second, the abettor only intended a specific, maybe less harmful result. Third, the act actually caused a different and more serious effect. And fourth, this is the clincher, the abettor knew that this more serious result was a probable consequence of the act. Let's use a practical example, the kind you might see in an exam. So A tells B to give C a severe beating. B does it, but C tragically dies from the injuries. Now here's the question. What is A liable for? Well, if A knew that such a severe beating could likely cause death, then A isn't just liable for abetting assault. No, A could be held liable for murder. You see how the liability expands to match the foreseeable outcome? A classic case that really highlights this principle is R versus Pemblington. Now, the facts were different, but the legal principle is spot on. The court in that case really emphasized how important knowledge and foreseeability are in the eyes of the law, especially when the final outcome isn't what was originally intended. It's a great case to remember to support the idea in Section 53. Now for the exam angle. It's absolutely vital to know that this section directly corresponds to the old Section 113 of the IPC. Understanding this idea of extended liability is crucial for both your prelims and mains exams. So, a quick revision. Under Section 53, an abettor is liable for any consequence they could have reasonably foreseen as likely, even if they didn't want it to happen. All right, let's move on to our next section and build on this concept. Now we'll discuss Section 54 of the Bharatiya Nyaya Sanhita 2023. This section takes the abettor's liability to a whole new level based on one simple thing. Were they physically there when the crime went down? This provision is about as direct as it gets. It says, if someone abets a crime and then shows up to watch it happen, the law stops seeing them as just a helper. Legally, they are treated as if they committed the crime themselves. So their presence at the scene literally transforms their role from an accomplice into a principal offender. It's a huge deal. For Section 54 to kick in, 3 conditions have to be met, no exceptions. First, there had to be some kind of abetment before the crime. Second, the crime was actually committed. And third, the abettor was physically present at the scene. You need all 3 of these for this section to apply. Let's make this simple. A encourages his friend B to attack C. Then, when B is actually attacking C, A doesn't just watch from his window. He's right there, standing nearby, maybe shouting things to cheer B on. In this case, the law will treat A as if he was the one throwing the punches, even if he never touched C. His presence is considered active participation. And this very point was beautifully illustrated in the landmark case of Shri Ram versus State of UP. Here, the Supreme Court of India was crystal clear. It held that the mere presence of an abettor at the crime scene can be considered active participation, which makes them just as liable as the person who actually committed the act. For your exams, remember this. Section 54 corresponds to the old Section 114 of the IPC. Questions that ask you to distinguish between abetment and active participation are very common in both judiciary and APO exams, which makes this section a hot topic. So let's revise it one more time. Section 54 says if an abettor is present at the crime, he's treated as the doer. Simple as that. Okay, time to tackle our final section for today's deep dive. Let's talk about Section 55 of the Bharatiya Nyaya Sanhita, 2023. This is a very serious one because it deals with abetting the most grave and heinous offenses. Now, the key takeaway here is huge. If you abet a crime that's punishable with death or life imprisonment, the abetment itself is a crime, even if the main offense never actually happens. And notice the two levels of punishment. If nothing happens, it's up to 7 years. But if someone gets hurt during the failed attempt, that punishment can shoot all the way up to 14 years. So let's quickly recap the essential ingredients here. First, the abetment has to be for a really serious offense, one punishable with death or life imprisonment. Second, and this is the unique part, the main crime is not committed. And third, the punishment gets much tougher if any hurt is caused as a result of that abetment. Let's see this in action with an example. A hires B, a hitman, to murder C. B makes the attempt, but fails to kill C, only managing to injure him. Now, even though the murder never happened, A, the person who instigated the whole thing, can be punished with up to 14 years in prison simply because hurt was caused as a direct result of his abetment. A very important Supreme Court case that backs this up is Chetrish Kumar Chopra versus State. In this case, the court clarified that abetment isn't just about helping, it also includes instigation, and that act of instigation is punishable on its own, whether or not the main crime ever gets carried out. From an exam point of view, please note that this corresponds to the old Section 115 of the IPC. This is an extremely important section for both prelims and mains, especially when you're studying inchoate offenses, which are basically incomplete crimes. So, for a quick revision, Section 55 punishes you just for abetting a very serious crime, even if that crime fails. All right, we've made it through Sections 53, 54, and 55. That was a lot of information, I know. So now, let's pull it all together. We're going to compare them side by side to make sure these concepts are locked in your memory for good. This little table really simplifies everything, doesn't it? Section 53, you're liable for a worse outcome if you knew it was likely. Section 54, if you're present at the crime, you're treated as the main offender. And Section 55, just abetting a serious crime is punishable even if it never happens. Each one addresses a different way that liability is expanded. So what are the final, most important takeaways for you today? Well, all these sections are designed to extend criminal responsibility to the mind behind the crime. So when you're studying, just focus on these keywords. For Section 53, it's knowledge. For Section 54, it's presence. And for Section 55, it's the gravity of the crime. And of course, always remember the old IPC sections, 113, 114, and 115, for any comparative questions. I hope this breakdown has helped you get a much clearer understanding of expanded liability and abetment under the BNS. For more judiciary-focused legal content just like this, make sure you stay connected with Ganga Education. So in today's session, we're going to break down Section 56 in a really structured way. We'll start with a quick intro, dive into its core provisions, look at a practical example and a landmark case, see how it compares to the old law, and then most importantly, we'll cover why it's so crucial for your exams. All right, so let's get started with a proper introduction to Section 56. आज हम डिस्कस करेंगे Section 56 of the Bharatiya Nyaya Sanhita 2023. Now, what's this section all about? Well, it deals with a very specific situation. What happens when someone encourages or helps in a crime, but that crime never actually takes place? Okay, let's look at the exact wording of the law and pull out the most important keywords you need to know. The section says, whoever abets an offense punishable with imprisonment shall, if that offense is not committed, be punished. So what does that really mean in simple language? It means if you push someone to commit a crime that has jail time, you can still be punished. And here's the kicker. It doesn't matter if they actually go through with it or not. Just the act of abetment, the encouragement itself, is the offense here. So to really get a grip on this, there are a few key ingredients. First, there has to be abetment of a crime that's punishable with imprisonment. Second, and this is the most important part, the crime itself must not have been committed. Third, there shouldn't be any other specific law that already covers this exact type of abetment. And finally, there's a special rule for public servants, which is super important. Now, let's talk about punishment, because this is where it gets really interesting. For a regular person who abets a crime, the punishment is up to 1/4 of the maximum jail time for that main offense. But if the abettor, or the person being abetted, is a public servant, someone whose job it is to prevent that crime, the punishment jumps up. It can go up to 1/2 of the maximum term. This shows just how seriously the law takes the role and responsibility of public servants. Okay, theory is one thing. To make this crystal clear, let's walk through a simple, practical example. So let's say A instigates B to give false evidence in court. But B thinks about it and says, "Nope, I'm not doing that." He refuses. Now, here's the question. Is A off the hook? Absolutely not. Even though the crime never happened, A is still guilty of abetment under Section 56. This is a perfect illustration of the principle. The main offense doesn't need to happen for the abettor to be liable. All right, now let's look at a landmark Supreme Court case that really cements this concept. We're talking about the 2009 case, Chitresh Kumar Chopra versus State NCT of Delhi. In this case, the Supreme Court laid it out very clearly. They said abetment can be through instigation, conspiracy, or intentional aid. And this is the golden nugget for your exams. Liability for abetment can arise even if the main offense is never completed. So the key takeaway, the mere act of instigation is enough. Now, a very important point for your exams, especially for those of you who study the old laws. You might be wondering, what did this section used to be? Well, Section 56 of the Bharatiya Nyaya Sanhita 2023 is the direct replacement for the old Section 116 of the Indian Penal Code 1860. It's a one-to-one correspondence, so make a note of that. Okay, let's switch gears and focus on what really matters for you, the exam perspective. Why is this section so important? So, let's break down exactly how Section 56 is a hot topic for your exams. Listen closely, because this section is a goldmine for questions. For your prelims, you can bet on seeing direct questions about the punishment, that whole 1/4 versus 1/2 difference. For mains, this is perfect fodder for those tricky problem-based questions. And for the APO exam, there's a high chance of direct questions on the concept itself or its old IPC equivalent. And a pro tip, quoting the Chitresh Kumar Chopra case in your answer will definitely make it stand out. All right, before we wrap up, let's do a super quick revision. 3 things you absolutely cannot forget. 1, we're talking about Section 56 of the Bharatiya Nyaya Sanhita 2023. 2, the core idea is punishing abetment even if the crime doesn't happen. And 3, from an exam point of view, it's all about the punishment rules and the special liability of public servants. Got it? For more judiciary-focused legal content just like this, make sure you stay connected with us here at Ganga Education. In today's explainer, we're going to break down 2 really important sections of the Bharatiya Nyaya Sanhita 2023. We'll be focusing on sections 58 and 59, which deal with the crime of hiding another crime. Now, this is a super critical topic for your upcoming exams, so let's get right into it. So, here's what we've got on the agenda. First up, we'll talk about the basic idea of why hiding a crime is, in itself, a crime. Then, we're going to do a deep dive into Section 58. That's the one that applies to just about anyone. After that, we'll look at Section 59, which is specifically for public servants. Then, we'll put them side by side to see the differences. And finally, we'll wrap it all up with some key takeaways for your exams and a quick revision. Okay, let's start with the big picture. You know, a core principle in our criminal law is that being guilty isn't just about committing the crime yourself. Even if you just know about a plan to commit an offense and you hide that information, you could be held criminally liable. The law does this to make sure that anyone who helps a criminal, even by just staying quiet, is held accountable. And this is really what you need to grasp. The Bharatiya Nyaya Sanhita has these very specific rules to punish people who make a crime easier to pull off simply by concealing the plan. The whole idea is that hiding something like that is a breach of your social duty, and well, it gets in the way of justice. That's why these sections are so crucial for keeping law and order. All right, let's get into our first key section for today. Think of this as the general rule about concealment. It's the one that applies to any person, doesn't matter who you are or what your job is. आज हम डिस्कस करेंगे सेक्शन 58 of the Bharatiya Nyaya Sanhita, 2023. So to put it simply, this section punishes anyone who knowingly hides a plan to commit a really serious crime. We're talking about one that could get someone the death penalty or life in prison. The most important thing here is the act of hiding the plan with the goal of helping that crime actually happen. इस section में 4 important चीजें हैं. First, there has to be a design, which just means a solid plan to commit a serious offense. Second, the person accused must have knowledge of this plan. Third, they have to voluntarily conceal it. Now, this can be done by doing something, by not doing something you're supposed to do, or even by lying and giving false representation. And fourth, their intention has to be to make the crime easier to commit. Let's make this crystal clear with an example. Imagine A knows that a dacoity is going to happen at B's house. To help the criminals, A goes to a magistrate and lies, saying the dacoity is actually planned for C's house. So the police rush over to C, and while they're gone, the dacoity at B's house goes off without a hitch. In this case, A is totally punishable under Section 58 because he used lies to conceal the crime. This brings us to a landmark case, State of Maharashtra versus Muhammad Yaqub. In this case, the Supreme Court made it very clear. They said that if you know about a crime and you intentionally do something to help it happen, you are criminally liable. You don't have to be there for the final act to be guilty. And just for your exams, you've got to know where this came from. ये section पहले IPC section 118 था, जो अब replace हो चुका है by the Bharatiya Nyaya Sanhita 2023. Okay, so now that we understand the general rule, let's build on it. Section 58 was for everybody, right? Well, Section 59 sets a much higher bar, and it's aimed specifically at public servants. They are held to a higher standard of duty, and this section reflects that. अब हम discuss करेंगे Section 59 of the Bharatiya Nyaya Sanhita 2023. So what this section does is it targets a public servant who hides a plan to commit a crime that they are legally supposed to prevent because of their job. This really shows just how much responsibility and trust we place in our public servants. So let's break this one down. First, the accused has to be a public servant. Second, and this is the most important part, it must be their legal duty to stop that specific crime from happening. Third, they have to know about the criminal design or plan, and fourth, they have to intentionally conceal that information, which means they are failing to do their duty. Here's a simple example. Let's say a police officer finds out that a person named B is planning a robbery. Now, it's that officer's fundamental duty to prevent crimes like this. But instead of reporting it, he deliberately keeps the information to himself to help B get away with it. In this situation, that officer has betrayed his duty and would be held liable under Section 59. In this area, the case of Kartar Singh versus State of Punjab is really important. The Supreme Court, in its judgment, really hammered home the point about the strict duty and responsibility of government officials to prevent serious crimes and maintain public order. This case just reinforces that high standard we expect from public servants. And you guessed it, this section also has an old counterpart. ये section पहले IPC section 119 था, जो अब replace हो चुका है. All right, to make sure you've got this down perfectly, let's compare these two sections side by side. Nailing the difference between them is absolutely key to answering questions correctly in your exams, whether they're multiple choice or essay style. Okay, look at the table. The main difference is who the section applies to. It's that simple. Section 5.8 is the general one. It applies to any person. But Section 5.9 is special. It's only for a public servant. And what's more, Section 5.9 kicks in only when that public servant had a specific legal duty to stop that crime. That's what makes it so much stricter. And here we are, at the most important part of our session, the exam focus. Let's do a final, quick revision to lock in everything we've just learned. Listen closely. Both sections 58 and 59 are extremely important for your judiciary prelims and mains. In the prelims, you can bet on getting questions about the differences between them. For the mains, you'll probably see a problem-based question where you have to apply them. And for the APO exam, there's a very high chance of a direct question from this topic. All right, let's do a lightning-fast revision. 1. Sections 58 and 59 of the BNS are both about punishing someone for hiding a criminal plan. 2. The key concept is the difference. Section 58 is for anyone, Section 59 is the stricter rule for public servants who have a duty to act. And 3. You absolutely have to know these sections for both your prelims and mains. And that was our detailed breakdown of Sections 58 and 59 of the Bharatiya Nyaya Sanhita 2023. We really hope this has cleared things up for you. For more judiciary-focused legal content, make sure you stay connected with Ganga Education.
Today, we're going to dive into a really interesting section of the Bharatiya Nyaya Sanhita 2023. We'll be exploring Section 60, which deals with the act of concealing a criminal plan. It's all about stopping a crime before it even happens. So here's our game plan for today. We'll start with a basic introduction to Section 60. Then we'll look at the exact wording of the law, the core provision, and break down its key ingredients. After that, we'll see how it works in practice with a clear example and a landmark case. And finally, we'll wrap up by discussing its importance for your exams, followed by a quick revision. Ready? Let's begin. All right, so let's get right into it, starting with the introduction to Section 60.
आज हम डिस्कस करेंगे Section 60 of the Bharatiya Nyaya Sanhita 2023. Now, the board idea here is pretty simple but powerful. Helping a crime happen, even indirectly, is a crime itself. This section holds those people accountable who don't commit the crime themselves, but who know about a criminal plan and help the offenders by simply keeping quiet about it.
Now, let's get to the heart of the matter, the core provision. In law, the exact words used are everything. So let's see what the BEAR Act actually says. Whoever voluntarily conceals the existence of a design to commit such offense. So, what does this mean in simple terms? Well, it's straightforward. If you know that a crime is being planned, and you deliberately hide that information or even lie about it, you're going to be held liable under this section. It's about that intentional silence or misrepresentation. To really master this section, you've got to understand its building blocks. So let's break down the most important keywords. Okay, so there are 4 essential ingredients to make out an offense under this section. First, there must be a design to commit an offense. This just means a plan or conspiracy to commit a crime has to exist. Second, knowledge of the design. The person accused must actually know about this plan. You can't be held liable for something you didn't know about, right? Third, voluntary concealment. This is crucial. The person must have hidden this information willingly. This can be done by an act, like lying, or by an illegal omission, meaning you had a legal duty to inform the authorities, but you chose not to. And fourth, facilitates the offense. Your act of concealment must have made it easier for the crime to be committed. Theory is great, but let's see how this all works in the real world. A practical example and a landmark case should make things crystal clear. Let's take a simple example. Suppose A finds out that his friend B is planning to steal from a warehouse. Now, instead of reporting it, A decides to stay silent. His silence makes it easier for B to go ahead with the theft. In this situation, A has committed an offense under Section 60. And if the theft is actually committed, A could face imprisonment up to 1/4 of the longest term provided for that theft. And this isn't just a textbook concept. The Supreme Court affirmed this principle in the landmark case of State of Maharashtra versus Mahad Yaqub in 1980. The court made it very clear, just knowing about a criminal plan and intentionally hiding it is enough to attract criminal liability. It doesn't matter if you didn't directly participate in the final crime. Okay, let's switch gears and talk about what this means for you, especially in the context of your upcoming exams. Now, this is a very important point for your exams, so make a note. This section, Section 60 of the BNS 2023, corresponds to the old Section 120 of the Indian Penal Code 1860. So it's essentially the same concept, just under a new number in the new Sanhita. So, why do you need to know this section inside out? Well, judiciary prelims और means दोनों के लिए ये section बहुत important है. You can expect direct problem-based questions from this area. It's also a key topic for APO exams. Honestly, a solid understanding of Section 60 can really give you an edge over other candidates. All right, we've covered a lot of ground. Let's do a quick final revision to lock in all the key points. So let's recap the 3 main takeaways. First, we're talking about Section 60 of the BNS 2023. Second, its core concept is simple. Intentionally hiding a criminal plan is a punishable offense. And third,
For your Judiciary and APO exams, this is a high-yield topic that you absolutely cannot afford to miss. For more Judiciary-focused legal content, stay connected with Ganga Education. In today's explainer, we're going to tackle a really important topic, Section 61 of the new Bharatiya Nyaya Sanhita 2023. This section deals with the offense of criminal conspiracy. So, let's start with a question to get you thinking. Can just planning a crime, just the act of agreeing to do something wrong, actually make you a criminal, even before you take a single step to carry it out? Well, that's the fascinating question at the heart of what we're exploring today. All right, let's dive right in. We're focusing on Section 61 of the Bharatiya Nyaya Sanhita 2023. This is the section that now defines what criminal conspiracy is and also lays out the punishment for it. So let's get into the details. Okay, so here's the exact wording from the Act. It says when two or more people agree to do an illegal act or even a legal act using illegal methods, that agreement itself gets labeled as a criminal conspiracy. You see, the law is trying to step in early to stop a crime before it even happens. The most important thing for you to remember is this: the agreement itself is the crime. So, to prove a criminal conspiracy in court, you need to satisfy 3 essential conditions. Think of it like a checklist. First, you need 2 or more people. You can't conspire all by yourself, right? Second, there has to be an actual agreement between them, what we call a meeting of minds. They have to be on the same page. And third, that agreement must be to do something illegal or to achieve a legal goal but through illegal means. Now, what about the punishment? Section 61 sets up a pretty clear 2-level system. If the plan was to commit a really serious offense, one that's punishable with death, life imprisonment, or jail for 2 years or more, then the punishment for the conspiracy is the same as it would be for abetting that offense. But for all other less serious conspiracies, the punishment is a bit lighter, up to 6 months in jail, a fine, or both. That second part of the definition, a legal act by a legal means, can sometimes feel a bit confusing. So to make it absolutely clear, let's walk through a practical example, the kind you might actually see in your exam questions. This example really brings it to life. Imagine 2 people, A and B. They agree they want to win a big government contract. Now, is winning a contract legal? Of course it is. But here's the twist. They decide the way they're going to win it is by bribing the officials. And bribery is an illegal act. So the moment they made that agreement, even before any money changed hands, they've committed a criminal conspiracy under Section 61. Now, in law, case precedents are everything. And for criminal conspiracy, one of the most important cases you absolutely must know is Kihar Singh versus State Delhi Administration. This was a landmark judgment from the Supreme Court all the way back in 1988. In this case, the Supreme Court pointed out something very practical. It said that conspiracies are, by their very nature, hatched in secret. You're not going to find a written contract or an email chain detailing the crime. So the court held that these agreements are usually proven by circumstantial evidence, by looking at the actions of the people involved and connecting the dots. So, why is this case so crucial for your exams? Well, first, it establishes that you don't always need direct proof like a confession to prove conspiracy. Second, it empowers the courts to infer that an agreement existed just by looking at the conduct of the accused. And for your mains exam, believe me, mentioning the principle from the Kihar Singh case in your answer will show the examiner you really know your stuff. Now, for those of you who have studied the old criminal laws, this is a very important update. Under the old Indian Penal Code of 1860, this whole topic was split between 2 sections, 120A for the definition and 120B for the punishment. The new Bharatiya Nyaya Sanhita 2023 has made things much simpler by combining both of these into a single comprehensive Section 61. Okay, now for the part you've all been waiting for. How important is this for your exams? Let me be very clear. Whether you're aiming for the Judiciary or the APO exam, this section is an absolute must-know. And here's why you need to master it. This is a favorite topic for question setters. For your prelims, you can expect direct questions asking about the ingredients or the punishment. For your mains, you're very likely to get a detailed question, maybe even one that requires you to cite case law. And if you're preparing for the APO exam, you have to be ready for problem-based questions built around this section. All right, we have covered a lot of ground. So to make sure everything is locked in your memory, let's do a very quick revision of the most important points. So, here are the 3 main things to take away. First, Section 61 of the BNS is your go-to section for criminal conspiracy. Second, the core idea, the heart of this section, is that the agreement itself is the crime. And third, from an exam point of view, this is a high-priority, high-yield topic for both judiciary and APO exams. So remember this key principle. In the eyes of the law, a shared criminal intent can be just as serious as the criminal act itself. It's a fascinating concept that really makes you think about where a crime truly begins. We hope this breakdown of Section 61 was helpful for your preparation. For more judiciary-focused legal content like this, make sure you stay connected with us here at Ganga Education.
Thank you for watching this session. If you found this lecture useful, do like, share and subscribe to Ganga Education. Keep learning, keep growing and stay connected for more law lectures.